Sir, there is one question from Mr. Satyendra, sir. Sir, if the IP tactics of XYZ company are mapped under the IP roadmap of XYZ company, which uses defensive publications to weaken competitors' IP position, if such an IP strategy is valid, and if so, how its validity is ensured?
So basically, defensive publication, there are a
Yes.
lot of companies that do. It is their strategy. You can't stop defensive publication. You cannot. It is not illegal. You cannot stop. So at times that happened that if it is not my core area, and I want to block a competitor to get a patent, so I publish something which would not allow them to get a patent. At times it is done. It is not illegal.
Thank you, sir. Sir, with respect to pharmaceutical industries, generally there is the strategy of obtaining patents with slight modifications. But however, the after the evergreening of patents case, the in India the position is very different. Can you just point out as to how the strategy of pharmaceutical companies with respect to IP is?
See, in India, evergreening is a myth. The
Sir,
You cannot evergreen anything. So if somebody, any invention, if somebody wants to apply for a patent application for an invention, and which is a trivial improvement, let us assume an effort to evergreen. Now tell me, patent examiner would examine based on the patentability, novelty, and inventive step. If it
yes, sir.
is novel and inventive, then it is not an evergreening. If if it is evergreening, then it will never be granted. And importantly, and which is in India, there is the law section 3D is very powerful section, which is additional layer above the section above the inventive step. So for a second generation compound, you cannot have physiochemical some data, technical data you give on bioavailability. It will not be accepted. It to get a patent, you need to submit, you need to show that is a therapeutically active. That means it has good impact on human body or animal body. So therefore, in India, especially in India, evergreening is extremely difficult. So in other country, the
Yes, sir.
requirement, data requirement is not as stringent as in India, but but again, I'm saying inventive step is a set criteria. The existing patent in an existing drug molecule has some role to play. So now I have modified, and which is solving a technical problem. Then only you get a patent. Now, without solving a technical problem, you will not get a patent. And if you get a patent, that is a bad examination. There are people who can oppose that examination. In US, it can be revoked. In India, you can file a pre-grant opposition. Everywhere it can. So once it is through a valid and good examination, if it you get a patent, then it is not evergreening.
Thank you, sir. Sir, with respect to academicians, sir, uh, because the audience is majorly comprising of academicians who are into inventions and also academic writings. Sir, can you give us few pointers from the academic perspective? How academicians can leverage on IP, sir?
See, academician is a huge human resource. The kind of IP embedded in universities is unbelievable. Only thing we do not unleash, we do not see whether it is patentable or not. The kind of or quality technology which are being developed by the universities in India and overseas are remarkable. Only difference between India and other country or a developed nation like US and Europe, they have a technology TTO, technology transfer offices. They keep on assessing it, whether we can have IP, we can develop IP from this. If we develop IP, we can how we can leverage IP. So, but India, that is lacking. But if an academician know, there are various like TIFAC is there, CSR, UDRIP is there. Uh, the academicians can reach out to these government agencies to check whether their inventions, they can file a patent application for that.
So there is one question from Mr. Nikhil Kumar. Sir, this is with respect to the time limits of PPH, sir, Patent Prosecution Highway. Sir, can you please tell us about the time limits with respect to patent?
In prosecution highway, so each country has a particular, I cannot off the shelf tell you the, so in US, if you want to expedite, there is a, I'm not talking about patent prosecution highway is country specific. India and Japan has a patent prosecution highway agreement. So there are hundreds of patent prosecution highway agreement. So I need to check if there is a specific example. Then I can check and let you know. Now I cannot give you off the shelf information, the timeline.
Thank you. Sir, with respect to the technology startups, sir, with respect to the standard essential patents that are there, so is licensing of those patents compulsory? And what would be the approach for startups to go for licensing?
Essential patent, you need to go and seek voluntary license first.
Sir.
So a standard essential patent, there's a body who says that these are the standard essential patent, and the spirit of or the philosophy of the standard essential patent, it should be given at a reasonable rate. So and they have to seek license from the company who has that SCP.
Okay, sir. Sir, in case the company is giving very unreasonable terms, is there any remedy that is available, sir?
You have you can go to court. That is the remedy is that you can go to court, and
Okay.
if somebody is misusing their dominance, you can go to competition commission as well.
How does the company's size reflect and determine the IP strategy of the company?
It is not about the size. It is all
Yes.
about what a company wants to do. What is their short-term goal, long-term goal? It is not about the size at all. Look at companies like Google or Qualcomm. When they started, when they were born, they kept on filing IP. They kept on creating IP. So IP, if you ask me the IP strategy should be any innovation. You should file your application. The question comes, if I have to go global, then which other country I have to go and file? How much money I have in my pocket to spend on IP? Because at times, especially for the startup, there are a lot of things to do with limited resources. So IP comes last for them. So therefore, it is all about, and for the big companies, again, they have their different, altogether different strategy. If you ask for Tata may be interested. Their priority could be start a new company in Africa. I'm just giving a vague example. I'm saying it all depends, irrespective of the size, what you intend to do, what is your goal. Based on your goal, my strategy will be finalized. If I am a licensing company, primarily if I am a licensing company, then I would I would file all my technology, protect all my technology, file patent application, because it would be my revenue will come from license. So again, my research would be oriented in such a way that I find the gaps. What is the need of the hour in that particular technology domain? If I know in a drug delivery system, there is a major gap, there is a major issue, so I'll work on the drug delivery system. And as a company policy, if I do not want to develop drug, I want to develop drug delivery system only, then I'll be licensing it to all the drug company. It depends what you want to do. It is not about your size.
Thank you so much, sir, for the elaborate clarification that it depends on the activities of the company rather than its size and its global reach.
Thank you, sir.
You are most welcome, and it's a really privilege to be part of Osmania University, this Know Your IP lecture series. Thank you once again.